Right. Let's get second and send the judiciary, and we're going to walk through page 27.
Good morning. For the record, Michelle Brown's Office of Legislative Counsel, and we're looking at page 27 as passed the House. I also just want to let you know I emailed a copy to all of you of the Domestic Violence Fatality Review Commission recommendations from 2023, which is including some of the recommendations that are in this bill. So you have that. I'm not going to go through it because you've got great witnesses who can talk to you more about the work with the commission. But I just wanted you to go origin for the policy that's in page 27. So the Domestic Violence Fatality Review Commission, this was created in 2002. This was I remember working on this and writing this one in my first few years when I started here. And you'll see in section 1 and subsection A talks about the purpose of the commission. So to examine the trends and patterns of domestic violence related fatalities, identify barriers for safety, the strengths and weaknesses in communities and systemic response to domestic violence, educate the public, service providers, and policymakers about domestic violence fatalities, and recommend policies, practices, and services that will encourage collaboration and reduce fatalities due to domestic violence. There's a lot of members on this commission. They make biennial reports to the governor and the General Assembly based on the data that they've gathered. I think Carolyn and Sarah, Charlie can talk to you about kind of their work and how they go about assembling that information and making their recommendations, but they get information from the medical examiner around homicides, and then they choose some to look at that were related to domestic violence, and they have a list of kind of criteria of what they consider to be related to domestic violence. And there's something that you'll see in section 1 that they're looking to do is to not just look at domestic violence related fatalities, but also near fatalities. So something that could have resulted in someone dying, but that did not. There was discussion a little bit before the bill was introduced, and then also in the House around, do you need a definition of what near fatal means? And, there's nothing, because we're not talking about like a criminal statute where you can be like super specific, and clear about that. I think it's fine to leave some room in there for interpretation for the commission to be able to determine what they consider on a case by case basis, what constitutes a near fatality. But again, I think probably it's a good conversation for the witnesses. So there's 3 changes in this bill. One of them is the inclusion of their ability to be able to look at near fatal incidents of domestic violence. The next one is at the bottom of page 1 in subsection B, a new language about the commission members who are going to sit on this board. Is intended to reflect the communities throughout Vermont, and appointing authorities shall strive to appoint persons from different racial and ethnic backgrounds, persons with a disability, and who identify as LGBTQ+. There is a change in the membership. So right now there are 17 members on the commission. You can see those starting on page 2, who's on there now. So the additional 5 members are on page 3. On subdivisions 18 through 23. Again, these were coming from the recommendations of the 23 report.
I think 23 is way too many.
A lot of people, yeah. I'm not the only one
I would say I think 17 is way too many. But adding 6 more just like too many.
Michelle, I know
I wouldn't want to snap it.
it's probably a question for the witnesses, but just for context in the House, do you know if they heard that the current membership is insufficient or just doesn't have the right people on it? Is that?
I think I would believe that the witnesses to say
Okay.
why they are advocating to have people with different experiences within the commission. And so that's it. So, so there's the change to include near fatalities. There's the addition of the 5 new members to the commission. And then there's the language about trying to encourage diversity amongst them.
The first piece on page 1, I'm all for it, but how it would, have folk from different racial and ethnic backgrounds, how would they check to make sure that's being followed or enforced?
It's not, so the way that it's drafted is not a requirement, right? Because you're looking for very specific numbers. So if you look at like one of the new folks to be added, a shared with experience and interest in combating domestic violence appointed by the Village Association. Maybe that there's someone who's perfectly suited for that, but they don't fit that criteria. So it's not a requirement. It's just more of an acknowledgement that having diversity on the commission finds that to be valuable.
Yeah. I don't know, I'm not trying to be facetious. I'm assuming that all sheriffs have an interest in combating domestic violence, but I get what you're, I get what their intent is. Committee, any questions for Michelle?
So, and then just so you, so some of those questions, as I mentioned, will be best answered by the witnesses, and just to let you know, you do have 2 folks who are part of that commission here. So ask those questions.
Yeah, we've got time, so Charlie, I'm assuming I don't think we've met.
Carolyn Hanson, I'm the chair of the Domestic Violence Fatality Review Commission, and I'm with the Attorney General's office.
Okay, great. I think we've got time, so I guess we can try to split it between the 2 of you, but also we can have you come back at a later date if you have longer testimony. But
That's great.
yeah, okay.
We're here.
I can do something high level and then turn.
Go ahead.
Yeah, okay. Good morning. I'm Charlie Glisserman. I'm the policy director at the Vermont Network Against Domestic and Sexual Violence. So nearly all states in the nation have a body like Vermont's Domestic Violence Fatality Review Commission. The Vermont Network has been a representative on the commission since it was created in statute in 2002. Speaking to the 2 pieces of this bill that we feel would strengthen the commission's work. So the first is allowing the commission to review trends and patterns of near fatal instances of domestic violence. This is a commonly reviewed condition in the commissions in other states. We think that it would strengthen Vermont's work as well, because these cases offer valuable insights into opportunities for intervention and prevention of completed homicides. Research indicates that about 65% of domestic violence homicides, either the victim or the perpetrator interacted with a criminal justice or healthcare professional before the event. And so we see there are opportunities for intervention that are missed, and that the commission can offer systems changes and analyze data to prevent future fatalities. The other pieces of the bill enable better representation of key stakeholders on the commission and directs those with appointing authority to consider diversity in their appointment. All Vermont communities are impacted by domestic violence, but they are impacted in like very different ways. And so we think that these changes will contribute new and important perspectives to the commission and improve systems of response for all Vermont communities. Carolyn has been working with the commission for a very long time, and I think can speak to the details of the commission's work and their justification for individual new appointments that they want added to the bill. But I'd also be happy to answer any questions.
Thank you. I think, well, committee, any questions? Sorry. So I guess I'll just repeat my earlier question regarding the number and additional folks that are being proposed to be added to the commission. Speak a bit more on that, please.
Absolutely. So, I think the membership of the commission is really where the strength of the commission comes from, is that you are gathering folks with different perspectives on domestic violence issues and different experience with systems that interact and respond to domestic violence incidents. So, as far as the kind of individual positions, I think that Carolyn can do a better job of speaking to why those specific perspectives are really important on the commission. I think some of these folks have been participating in the commission business, just haven't been specifically listed in the statute. And for example, on page 3, line 9, a restorative justice practitioner from a community justice center. Because community justice centers are now able to take cases of domestic and sexual violence for restorative practices, that is a kind of new perspective to the work that I think would be beneficial for the commission. From our perspective as a member on the commission, we have felt like the commission and its size has not held back the commission or disrupted its work. In fact, we think that that is where the real strength of the commission comes from. So I know Carolyn can speak to the details, but that's our perspective.
Okay, thank you. Anything further?
I will just say again, I do think 23 is too many. Personally, I think you have a point. If you have more stakeholders, it's a stronger group. So instead of 23, we could have 30, it would be even stronger. And 50 would be super strong, but 23 just seems to be an unwieldy number for Southern like this.
Is there a financial implication? Is that what the concern is?
I guess, I don't see a per diem piece.
I don't believe there is a per diem. The survivor representative on the commission has a stipend, can't recall, from the Vermont network. But I believe that is the only per diem offered to members.
Yeah.
Carolyn can speak to that as well.
Yeah, so I guess it's not financial, it's more a sense that it's just too many. I feel like as we build these things out, I can only think of a couple of instances where we go over 20 people on this sort of commission funding. That's my opinion.
And both of you are on the commission?
The Vermont network
Yeah.
I am not personally, but my colleagues.
Okay, thank you. Do you want to speak?
Sure, yeah, I'm happy to. So again, my name is Carolyn Hansen and I'm with the Attorney General's office. And a part of my job is to chair the Domestic Violence and Retaliation Review Commission. I've been doing that since 2014. So I'm the person in charge with herding everybody together and running our meetings and gathering witnesses and putting together the report that you all get. And as Michelle mentioned, we're only required to do that every other year, but as a practice, we've been doing it yearly because we think it provides some valuable information to you all about what's currently happening with domestic violence in Vermont in terms of the statistics that are in that report. And also, if we have recommendations, we don't always have recommendations for you every year, but if we have recommendations, we include that. So I want to talk about this a little bit of time. I want to spend it talking about what you're interested in. If I forget one of your questions, please tell me. So we thought very hard about the idea of expanding this. This is not something we have asked for before, but we felt like it was time to make some changes and to expand our commission to better reflect current practices in Vermont. So, for example, as Charlie mentioned to you, now that restorative justice is involved with domestic and sexual violence, we thought that they should have a seat at the table. We're not really going from 17 to 23 because what we have done is in order to get some additional perspective, we have allowed alternate. We've allowed a couple of agencies to have an alternate member, which generally both members come. So to explain that, what I mean by that is, for example, when the state police hire the person to be the victim services director, that's a very different position and a very different perspective than somebody who is doing, responding to domestics. And generally the person the state police appoint is someone in a supervisory role. So I wouldn't say they have day-to-day work doing that, but they are supervising people doing that. So both of those people have been attending, the victim services director and the state police representative, both appointed by the commissioner. But we just wanted to put that into statute, because what we don't want to have is, for example, if we had a different commissioner who just thought, I only want to send one person, we would lose out on having both of those perspectives. So we thought it made a lot more sense to put that into the statute, or to ask you all to put that into the statute. Given that we now have this role at VSP, and we actually have more than one person in that role.
Can I'm
Yeah.
sorry, I'm a little confused now. I'm looking at the list. Are you saying that these 6 new folks are already attending?
2 of them.
2 of them are. I see.
Yes.
And which 2 are those?
The other one I was about to mention to you is the person who is the victim services person for the Department of Corrections. Again, for the exact same reason. Corrections didn't always have somebody employed to address and help victims. So now that they have that, now that both the state police and the Department of Corrections have that position, they didn't when you first did the statute. We thought it was important to have both those perspectives at the table. I'll just run through the other positions. You asked about why it says a sheriff with experience or interest in domestic violence. And that language we also was intentional, because not all sheriffs are involved in investigating complaints, as you know, and some of them, given the way that they are funded, they spend more work around doing traffic work and things like that. And so we didn't want a sheriff who either didn't have an interest or didn't have a background in working with domestic violence. So that was intentional, as well as to specify that the appointment be someone who has an interest or is investigating domestic violence. There's similar language around the deputy state's attorney or the state's attorney position. We've always asked the appointment authority there to appoint someone, and right now it's Michelle Donnelly from Washington County, of course, prosecutes a lot of domestic violence cases. But it is important to us that the people at the table have some experience and background and interest in the work. We added, the other positions we added was, we've always had a network representative, as Charlie mentioned. We haven't always had a victim advocate who works with state's attorneys. So we've always had prosecutor, but again, kind of the same thought process as with the state police and with corrections. Somebody who's prosecuting domestic violence has a little bit of a different perspective than somebody whose primary role is with victim support. And so we thought this non-confidential advocate position that the state has in every single state's attorney's office, it would be an opportunity for us to get another perspective that we don't currently have at the table. And I think I've covered all the new people, but we were very thoughtful about it. We're certainly mindful of what you said. And, I hope you're not right and that this is going to be a complete pain in the neck for me, but we don't want to come back to you all very often. So we felt like this would round out our commission. It has definitely been a workable number, the amount of people we have now. I mean, this is not an open group. That's important to keep in mind too. So we don't have people coming in and participating. We don't share facts with them. So if we wanted, for instance, the perspective of somebody who does restorative justice, we could invite them to come as a witness and we could ask them questions, but we wouldn't be able to share any information with them. And so we really want a group of people in the room that provide a lot of different perspectives that, we think this is a very powerful group because we have time to really reflect on what's happening with domestic violence and to spend time talking about it and build it. When you have the same people in the room over time, you build a lot of trust. So we also have very good discussion. It's not It's not just, sort of me throwing information out there to them. I would say this is a very active and interactive group. And I think we can manage that, even adding a few other people there. You asked about the language, adding, that we wanted to be mindful of appointments to the diversity in Vermont. And I think Charlie explained that really well, but we think it's just important that it's for the public to see that that is a goal, that we want our commission to better reflect our population. And we do have a few appointing authorities. And so when you add language like that, it helps us to provide a reminder that that's the intent, is to try to make our group more diverse than it currently is. And near fatals, I don't know if you all have questions about that. I got a lot of questions about that from your colleagues at the House, but we don't review every single case. We pick cases to review. And so we don't think this would add to our workload. We would potentially review a case that was a near fatal case, maybe perhaps rather than fatality at one point. And we've had the opportunity in the past to hear from a survivor, and it was a very, very powerful, very powerful testimony. And we learned a lot of things that, when we talk with survivors' families, we learn a lot of things, but being able to have the perspective of someone who has been there and gone through the experience, we don't always get that. And as a practical matter, we're not going to be able to do this very often because we only review closed cases. So if the person is still alive, then there's likely going to be legal proceedings going on, and we will not touch that case until it's completely closed case. The judicial process is finished. So it would be unusual circumstances to be able to review it, but we'd like to have the opportunity to do that.
So for the 4 other members, do you know if there has been, are they occasionally attending, and have those organizations said, yeah, we can send somebody to the commission? Is that any thoughts there?
For the sheriff, I know there's a very strong interest. Sheriff Harlow actually reached out and wanted to be part of the commission. And the tricky thing was we didn't have an easy fit for that. The local law enforcement representative is appointed by the governor. And he actually said, maybe she could take my spot, but then we would have lost a person who'd been a longstanding member. We didn't want to lose that person. And of course, that's always up to the governor anyway, who that is. But we really felt like they do different roles, and you all have given sheriffs a lot more responsibility around domestic violence with serving relief from abuse orders and helping people to get their belongings when they need somebody to do what's called a standby. And because they play, and that's a pretty unique role that they're playing, doing standbys. Most local departments don't do that, and sheriff's departments do that. So we felt like their role was just a little bit different. And in some counties, like where Sheriff Harlow is, they do a lot of primary investigation, and some places they don't really do any. So
Yeah, I'm just speaking for myself, at least. I don't have a problem with a larger commission if the commission itself thinks that it needs to bring in these other viewpoints, but also along with the fact that it doesn't sound like there's a financial impact. And if all of these organizations are to some extent expressing that they have an interest in participating, and somebody that they are interested in sending to the commission, I don't see it as problematic to expand the number. That's my opinion.
I am in agreement with you. I also just did a brief, granted we have 180, more than 180 boards and commissions, but I did a brief search and I've already found 2 that have more than 23 on it. So there is precedent for boards and commissions this size.
I'm not saying there's never been one this size. There are plenty who are at the high end. I feel there's a good deal of overlap, and I think you're seeing that as a strength. That you have 2 from one agency, and generally we try to avoid that. We try to have fewer people, but one representative. So, the other part of the bill, the near fatality, I go along with completely, and I fully understand that, and the diversity piece. I'm just saying, as somebody who sees these go through on a daily basis, we'll put out 15 or 20 of these in a year, different commissions and task forces and blue ribbon panels. And I feel like it's an ever expanding list. So, that's all I'm responding to is not that more couldn't be better, but that more sometimes isn't better. So.
I think that's a good point that, I don't think you're gonna see us again for a long time, but it really did come from us. I mean, we
Yeah.
did get a request from Sheriff Harlow, and I have had, non-confidential victim advocates sometimes ask about a spot on the commission, but it really came from us thinking, okay, we're gonna go to the legislature and ask to add a sheriff. Is there anybody else we're missing? So we really spent some time thinking about, is there other people we would really want in the room? And there may be times where one of those positions isn't filled. And I get your point about two different people from one agency, but I think it's really important to keep in mind that some of these positions are they're thinking about very different people. They're thinking about very different people. So having somebody that works with victim services, in, for example, the state police, and somebody who is investigating, they really have very different perspectives, and I think it's valuable to have both of the people.
Senator Bohowski, and then we'll move on to the next.
I am currently, and maybe it's been the bill, but I'm currently trying to put my eyes on who's currently on this, for the current 17 members, and if I had opened to the bill, I would be looking at it. My question around the sheriff, given that that's an elected position, is there any concern about the sort of disruption that could create, or potentially not having one of the 14 sheriffs have the expertise you're looking for?
I think if they didn't, that needs to become an open seat. And, no, I don't think it would be disruptive because, for instance, the governor has changed their appointment. They can change it every 2 years, and they have done so. So we make that work. And sometimes it's also nice to have another perspective come in. We do tend to have most people stay for a very long time until something else comes along. They move to a different job, for instance, or.
I'm fine leaving it as it is, but I wonder if there would be any thought around that language being a sheriff or someone within the sheriff's department. So it may not be the elected sheriff, it might be a deputy sheriff with that type of expertise. I don't know what your thoughts are on that, but I just the nature of an elected position being on the board is just different than all the others. So
I see what you're saying. Yeah. I guess I would defer to you all and what you discuss with them.
well, I would want to defer to the council because you're actually the people doing the work.
Sure.
But
Quick question. This is a tough one. How often do you meet?
6 times a year.
Your things?
Thank you.
You're welcome. Thank you for the time.
Absolutely. All right, next up, we have Wade Cochran. We're moving on to H44 now, our DUI bill.
this is a different, this is not the one we did yesterday.
No, Steve.
Okay, I was like, that was also a DUI bill.
Right, yeah. You like.
Has there been like a massive increase in DUIs?
Maybe in the house. That wasn't meant, no, that wasn't, okay.
Whoa.
anyways. Good morning.
So I'm Wade Cochran, Director of Enforcement and Safety at DMV. In reviewing the bill yesterday, I ran this by our legal, and we're in full support of it, except for one possible wording change. And I made some copies if you guys would like to see those. And I'll refer to page 22. And why we're saying or recommending the wording change, consulting with our legal, as it's currently written, 4 VSA subsection 33 violates 23 VSA 41.2. The prohibition of deferring, averting, or masking prohibition set forth 49 CFR subsection 384.226. So as you can see on what I've put in front of you, if you all have it, it basically strikes.
Just to clarify, what is a masking prohibition?
So the more of a legal term, which my attorney was here, maybe one of the attorneys, Dennis, could help because of more on him.
I would be curious, but yeah, we can get there.
Okay. But the wording changed, and this, like I said, this is the only issue that we had in there. And we would ask that we strike the language, where it starts offense or violation listed, and then on to the, to where it says, motor vehicle if convicted. Do you want to?
Which page are you on again?
I'm sorry, it's page 22,
22.
and it's under section 8 of 22.
Yeah, I'm not sure where we are. What's that? So are you looking, it sounds, are you referring to the as passed by the House version or the as introduced version?
I'm sorry, I think we referred the page 22 as passed by House. So. Search on task force.
Yeah, I don't.
That's 21 to 22 is the task force. Seeing 4 VSA starting on page 4.
Yeah, I did see that on page 1, and so, and then I went to page, or we went to page 22, and so there's. But it is also on line 8 of page 2.
No, that's definitions. All right, we're looking at different versions of.
I'm gonna show you the version that we're working on.
Okay.
Tonight. So
We
this
pulled it off.
is what we have.
Okay.
I think you might be looking at the official version that's online rather than.
I think I have to search.
Yeah.
It's gonna be line 11.
Where?
Sorry, that's page 1. Sorry.
Page 1, line 11, where it's starting with 4
Okay.
VSA 33.
Sorry about that.
No worries.
Our websites are confusing.
Yes.
So when you look, it starts on the 4th line down after driver's license. We obviously recommend keeping or commercial learner's permit as defined in 23 VSA 40 subsection 4103 for operating a commercial motor vehicle. Then striking with the offense or violation listed, and that carries through until motor vehicle if convicted. And we would pick up again with any offense or violation of traffic control law, other than parking, vehicle weight, vehicle violations. We, on the sheet that I handed out, it should be highlighted as well.
So can you, just so it's level set, now that we're on the right spot, can you just kind of summarize again what type of impact this would have? And I mean, I see the why underneath it, but yeah, what was the origin of this and why is it being proposed?
Sure. So the origin, and when they go over the bill to entirety, I'm sure that'll come clear. but the staff attorney was more concerned about the masking of the wording in this section. And that's why she felt that we should really change the wording to what we have put in there.
Committee, any questions?
Does anybody know what I'm asking?
Yeah, I don't-
Yeah, I don't think this,
What the
Attorney
names
Wakeman
are.
is going
Okay,
to testify here momentarily and, yeah, so that should fix that.
I'm not an attorney, and so I have a question about sort of the impact.
Would this change mean that someone who at some point got a DUI would never be eligible to get a commercial driver's license or permit? Because I have concerns around the disability aspects and discrimination. If someone has gone through rehab and treatment successfully, they shouldn't be barred from employment.
Sure, and I will get that answer for you. I'm not sure.
Okay.
I have to check with the CVSA.
Okay.
Part of that, but I do not believe so.
Okay.
I will confirm that.
Great.
Thank you. Committee, any further questions? All right, great, thank you. I think see that Marshall is next up, and I think it might be helpful if we have Dennis explaining. Are you
next because I have a 10:30.
Okay, yeah.
Thank you. So, and I'll just address real quickly as far as the testimony that was just provided. We are gonna have to take a look at that. I'm not actually sure that I do agree about the masking provision being affected. I'm not sure that it's affected by delinquency proceedings, but just by YO proceedings. I'm gonna have to take that back to our office and take a look at it before we can give any real comment on it.
This for our whole committee. Can you explain to us what the masking prohibition is?
So under federal law for commercial driver's license are regulated by federal law, where your normal driver's license is largely regulated only by state law. And the feds have a provision that says that you can't have things like deferrals or diversion or anything like that that allows you to sort of get a conviction but hide the conviction when it comes to driving convictions for people with commercial driver's licenses. I don't think that a juvenile conviction necessarily, or a juvenile adjudication necessarily counts as a masking provision. So that's what I'm going to go back and do some research on and see how the masking provision has been interpreted. I'm gonna, as far as the rest of the bill goes, I'm gonna share my screen quickly. Just get joined here. Oh, I'm sorry, I'm getting an invalid meeting when I click on my,
Oh, I'm sorry.
Let me
send it to you.
sorry.
I'll just take a moment.
I will start while I'm waiting for the screen to share by saying, we're in a little bit of an awkward position on this bill, which is that, this is one of these situations where that we hate, we try to avoid, and we did not avoid in this case, where we agree to language in the House, and then on review, we find a problem with it and need to make some adjustments in the, when we come to the Senate. Usually, we like to make sure we've gotten our legal review really nailed down by the time that we are, that we get through one body before we get to another body. In this case, we were into a situation where I ran this bill past some of our DUI defense attorneys while we were working on this bill. And only after it passed the House did I have the chance to run it by. Let me turn off the audio screen. Excellent. So it was only after we started to take a look at this bill that we determined that there was a problem. And I took a look at the language and thought there's an easy way to solve this problem without affecting the intent of the bill. And I sent that language to Attorney Wigmans and to Attorney Members yesterday. And the response to that language really revealed that we actually didn't agree in the first place on what the purpose of the bill was. And so that sort of opened up kind of a bigger split over this bill than I initially imagined. I thought that we sort of were in agreement as to the purpose of the bill, and I had some proposed language to kind of tighten it around that purpose and make sure that it was not too broad. And it turns out I was wrong about the purpose of the bill in the first place. So I want to just own that in terms of why we're changing our position between the House and the Senate. So to begin with, there's really two different problems. One is when people who are arrested on suspicion of DUI, whether that's drugs or alcohol, if they, for some reason, whether it's because they're arrested on suspicion of drugs, or because breath testing equipment is not reasonably available, or they're not able to give an adequate breath test, they're subject to a blood draw. And when someone's subject to a blood draw, they either have to give consent for the blood draw or there has to be a warrant for the blood draw. And what happens then is there's two possible problems that can crop up. One is what I thought the bill was meant to address, which is someone who physically resists a blood draw. So the officer has a warrant for a blood draw, the person's taken to a medical facility for a blood draw, and when the blood draw, whoever's administering the blood draw, sometimes it's a nurse, sometimes it's a phlebotomist, sometimes it's an EMT. When they go to administer the blood draw, somebody is going, not going to let you do it, physically preventing you from administering the blood draw. The second is somebody who has a warrant for a blood draw, they've been arrested on suspicion of DUI, they're taken to a medical facility, and they're asked to do a blood draw, and they put their arm out and they say, and the person who's administering the blood draw says, do you consent to this blood draw? And the person says, no, I don't consent to this blood draw. I'm only here because there's a warrant requiring me to be here. I definitely don't consent to a blood draw. Now, I thought that what we were dealing with this bill was problem number one. And I think that it turns out that the intent of the state's attorneys was to try to address problem number two. And that's where we end up with a disagreement about this language. So, typical Fourth Amendment law, you have an absolute right to refuse any consent to a search. That's what we teach people when I do know your rights classes for eighth graders. It's what we teach you to. When you are interacting with police, you always have the right to say, I refuse to consent to any search. I do not want to answer any questions. I would like to speak to my lawyer. You don't have the right, though, to physically prevent law enforcement from executing a search warrant. So to give you an example, as a lawyer, one of my clients calls me and says, the police are at my door, they have a warrant to search my house, and they're asking my consent to search the house. What I would advise them is, well, don't give your consent because that's waiving your Fifth Amendment right. But do let them search your house. If you block the doors to your house, you would be charged with obstruction of justice or impeding an officer or something like that. You are absolutely allowed to say, I do not consent to a search of my house. You don't have to consent to any search. And in fact, consenting to a search waives your right to then challenge the legitimacy of that search. And I have a couple of slides with cases that show that later on. How even if somebody has a warrant, if you consent to the search, if the warrant turns out to be defective, you've waived your right to challenge that warrant. So that's typical Fourth Amendment law. That means that it's okay to prohibit physical interference with the execution of a search warrant. So this is a case that basically says that if a search warrant comports with the Fourth Amendment, the state can criminalize the refusal to comply with the demand to submit to the required testing, just as the state may make it a crime for a person to obstruct the execution of a valid search warrant. So it's refusal to submit that they can criminalize. It's not merely saying, I do not consent to this. These two cases really show you that when it comes to consent, consent really doesn't matter in the case of a valid search warrant. So the first case is a case where there's a valid search warrant. That doesn't matter because the defense or the defendant's given the consent to search, and that whether or not someone gives consent, the government can search if they have a warrant. So it doesn't matter. Like, I mean, I think Senator Norris, he probably served search warrants before. And if somebody is saying, I don't consent to having my house searched, it doesn't really matter. Their house is getting searched. We see that all the time. And that's actually what we would advise our clients to say is, just to be clear, this is not a consensual search. And then allow them to do the search.
Marshall,
Yes.
the thing I'm trying to grapple with is how implied consent clashes or doesn't clash with this.
That's what I explained.
Okay, great.
So for decades, every state, including Vermont, not quite every state, most states had laws that said by choosing to drive on state roads, you're giving implied consent to be searched by means of a blood test or a breath test. And if you were arrested on suspicion of driving under the influence. There was a series of Fourth Amendment decisions from state courts and from the United States Supreme Court that started to call that into question. Such that by the time we got to the Birchfield decision, it was pretty much a foregone conclusion that the Supreme Court was going to, at the very least, limit the ability to conduct a implied consent test. The real question was what was going to be the status of complied consent breath tests. So the Supreme Court looked at this through the lens of a doctrine called search incident to arrest. Search incident to arrest is an ancient exception to the warrant requirement that says that whenever someone gets arrested, the government has the authority to full search of that person. But that's been limited by the Supreme Court for years and years. So for example, outside of the DUI context, they limited the ability to search someone's cell phone. They said, when you're doing a search incident to arrest, that doesn't give you the right to search a cell phone. That's what they were considering when they considered in Birchfield these implied consent DUI statutes that granted automatic consent for both blood and breath searches. So they looked at both blood and breath searches and they split the difference. Justice Alito wrote the majority decision, and the holding was that a breath test is unobtrusive. It doesn't reveal any detailed information about you. It's not painful. It's not embarrassing. And therefore, it doesn't implicate significant individual privacy interests, which they balance against the government's interest in collecting evidence. And they say, this is a case where the government's interest in collecting evidence outweighs the individual's privacy interest, and therefore you can conduct a search incident to arrest if what you're doing is a breath test. But a blood test, they said, is different because poking a needle into somebody's arm is much more intrusive. Drawing blood provides much more information available to the government, DNA, information about communicable diseases, all kinds of information. And then it's embarrassing, and then it's time consuming, and then it's painful. And therefore, blood tests are not subject to the search incident to arrest doctrine when it comes to driving under the influence. And so blood tests have to go through what we call normal Fourth Amendment procedure. The state has to get a warrant, and once they get a warrant, they can execute that warrant and get their blood test. Unlike a breath test, where consent is implied, and no warrant is necessary, and you can punish somebody for not providing that test. So all over the country, statutes that required people to consent to blood draws as a matter of implied consent were overturned. Statutes that required people to consent to breath tests as a matter of implied consent were upheld. That happened here in Vermont. We changed our drunk driving laws to comply with Birchfield. So the House version of H44, there's two changes that we think are unconstitutional. And those are these changes which say that a person suspected of violating the sections shall not refuse to submit to the collection of an evidentiary blood sample. And the other section, which provides that refusing the collection of an evidentiary blood sample is refused. So these are just two provisions that make it so that refusing a blood sample is refusal. When I looked at this initially, I thought, this is okay, this lines up with what Birchfield said, which is if you prevent somebody from, a typical Fourth Amendment law, if you prevent somebody from executing a search warrant, yeah, you can be prosecuted for that. But if you just simply say, I don't consent, you can't be prosecuted for that, as long as you don't prevent somebody physically from actually executing the warrant. When I ran this past our appellate team looked at it and said, boy, when we look at this, somebody could just say the words, I don't consent, and they might be prosecuted under this. And I said, oh, that's not what this was intended to do. We were intended to stop, to allow for the prosecution of people who are physically resisting blood collection. And so I then sent the email to Attorney Redmond and Attorney Oakros and saying, I think I have a change to this that would make it so that we can still get at what we're trying to get at, without lumping in people who are simply saying the words, I do not consent.
Marcellus,
Yes.
I think I'm still not fully grasping I get that blood draws are more intrusive and more private information is real, but there's still the implied consent piece. And if somebody has provided implied consent and then they are saying, now I don't consent. How would that not be criminal recusal?
You haven't provided implied consent to warrantless blood draws. You have provided, by driving on the roads, you provided implied consent to a breath test. And in Birchfield, they said, and that's what the laws were before Birchfield, was blood and urine. In Birchfield, they said, you can't do implied consent for blood.
When was Birchfield?
2016.
2016. And so that's what they divided it up. They said implied consent works for breath, but not for blood because it's so much more intrusive, with balancing between the government's interest and the individual's interest is different.
Senator,
So I guess what I'm trying to understand is the language in this bill would mean that it is taking away the ability for someone to say, no, I don't consent to a blood test. Correct. Okay. That feels problematic, just the name of bodily autonomy.
And so our proposal to amend that was to address the situations where somebody says, closes up their arms, wiggles away from the phlebotomist and says, I'm not going to let you draw my blood, and say that's punishment, because that is punishment. That is interference, physical interference with the execution of a warrant. But that simply saying the words, I do not consent, that can't be punished as refusal. And we think this actually goes beyond the Fourth Amendment. Birchfield analyzed this in the Fourth Amendment context. We think this goes to the First Amendment context. This becomes compelled speech because our understanding, and now that I've talked to a few people who have gone through this, is that if you just sit there silently, they still won't draw your blood. They need an affirmative consent to draw your blood. The phlebotomists do. And what this bill attempts to do is say, if you don't speak these words, you can be convicted of a crime. And I can't think of a single other place in law where the government can compel you to engage in speech and punish you if you don't, other than when you're subject to a subpoena or a court order to testify in court. Other than when you're under oath, I can't think of a case where compelled speech like that is okay. And in fact, compelled speech is subject to the most serious scrutiny under the First Amendment. So we think that this is a First Amendment problem and a Fourth Amendment problem and possibly a Fifth Amendment problem. And that gets to where the real problem of this is, which is this isn't people refusing police requests. What's happening is police are relying on healthcare providers to perform blood draws. Those providers are refusing to draw blood from people who don't consent to the medical procedure. Other states don't have this problem. They have contracts with private providers. They have trained police phlebotomists. They have EMTs who perform blood draws. So if police have a warrant for your blood, they're going to get your blood whether you say I consent or whether you say I don't consent. I've gone through, it's hard to do like a search for the non-existence of things, but my best search of all 50 state statutes, I could not find one state that has any statute around DUI consent that requires people to engage in state compelled speech. And I definitely looked through case law to see if anyone had tested such a statute, and I could not find a single court that had tested any statute like that. I cannot imagine that any court would uphold a statute that says you are required in the face of someone asking you whether you consent or not to say, I consent, otherwise you are going to be subject to criminal penalty. It violates the fundamental principles of the Fourth Amendment. It violates the First Amendment. I mean, on the backs of the business cards that our clients are given, we have, a line for them to write in. My name is, my address is, I do not consent to any search. I do not consent to any questioning. Please let me contact my lawyer. So that people have something to refer to, that this is the gold standard. This is what you say when you are in these sorts of situations. We also train children on that when we are doing know your rights classes in middle schools, high schools. It's what, when you read the ACLU's know your rights literature, that's what they say. Even the Department of Justice has pages that explain that you do not need to consent to a search, that you are always allowed to say, I do not consent to a search, though you're not allowed to interfere with the execution of the search.
Our ledge counsel is eagerly wanted to tell us something. Did you? Oh, I thought you. Okay.
Well, that's the end of my testimony anyway. I'm happy to answer any questions.
Senator.
Yes, I have one, Marshall. So even under implied consent, their moment was a breath test. They still can refuse.
Yes, but then you get a penalty.
They still can refuse, right? Then you get a refusal. So we could do away with all the warrants and all the invasion of privacy and so on and so forth. If we simply put in refuse to take a blood test, it's just a refusal. When we just simplify it, no, it's their Fourth Amendment, First Amendment rights violated. So if the state to prove beyond a reasonable doubt, once again, that they're guilty.
As long as the person is still allowed to say, I do not consent to this test, which is an exercise of your Fourth Amendment rights. With the warrant, they're still going to get the blood anyway.
I'm saying warrant, disregard all those things. Do you consent to the blood test or don't you? No, I do not consent. I've exercised the right. And it goes down as a refusal. It's the same as if I'm asking, okay, give me a sample of your breath. It goes down as a refusal if they refuse to give it.
And that's exactly what they said you can't do in Birchfield. That is saying that punishing someone for saying, I refuse consent to the test is what you can't do. Instead, you got to get a warrant. And with a warrant, then the government can get the test whether you say consent or no consent. Consent doesn't matter in the face of the warrant.
So are you also suggesting that the criminal refusal for refusing a breath test is also in violation of Birchfield?
No, because Birchfield was 3 cases combined. One was somebody who had refused a blood test and been criminally prosecuted for it. And he said, that's a violation of my Fourth Amendment rights. Another was a guy who refused a breath test and was criminally prosecuted for it. He said, that's a violation of my Fourth Amendment rights. And another one was a guy who was essentially told, if you don't do a blood test, you're going to be prosecuted. And so he submitted to the blood test. And so Birchfield really addressed the two, blood and breath, separately. And they said, if it's a blood test, you need a warrant, and the normal Fourth Amendment procedure applies because that is not a search pursuant incident to arrest. For a breath test, they said that's not very invasive. The balancing between the government's interest and the privacy interest really weighs in favor of the individual, or in favor of the government, that it's not very invasive and the government's interest is up there. And so you can be prosecuted criminally for the use of breath tests.
I go with the same.
Just trying to find a happy medium.
Senator.
I'm just curious when it gets to the point of the blood test and the nurse or the phlebotomist, whoever it is that's going to be doing the blood test, asks you the question. Are they the one that asks you the question? Do you consent to this blood test, or is it Is there an officer standing there that asked that question?
I asked that question to a lot of our DUI on-call attorneys, and I said that practice varies.
Oh, okay.
Typically, the person who's drawing the blood, really wants somebody to affirmatively say, I consent to this before they take the blood.
So in the case where the person doesn't consent to it, is there a police officer that's there that says, hey, I have a warrant that says regardless of if they consent or not consent, yes, this piece of paper, and then they go ahead and do it.
But it's because we're relying on a private provider who can simply say, I don't want to do that. That's the issue.
Huh.
No, nobody can, warrants are directed at law enforcement. I think that's been one of the problems in this bill throughout. The bill began with language about criminalizing people for failing to comply with the warrant. And that's actually impossible. The warrant is not directed at the target of the warrant. It's directed at law enforcement. It says this warrant allows law enforcement to go and seize this evidence in these circumstances. It's not like there's no warrant that says, you know, Marshal Paul, you are under arrest on suspicion of DUI, and therefore you are required to submit a blood sample. The warrant's law enforcement. It says you can go see the blood sample. The fact that law enforcement uses a third-party intermediary that isn't subject to the warrant and doesn't have to do what law enforcement says, yeah, that's where I think the problem comes down. And that's where other states have dealt with this by using contracted private labs. So I know some states use Quest laboratories, and they just got a contract with Quest Labs, and they can rate you with Quest Labs. So if they've got to hold somebody down and get the blood draw, they'll get the blood draw. Some states do it with emergency medical technicians. Some states have actually trained police officers to be phlebotomists. Some states have trained non-law enforcement officer police employees, so civilian employees of the police department to be phlebotomists. They've all dealt with this in other ways. I haven't heard of any state that's tried to say you're required to say the word I consent or you're going to be criminally punished. To me, that just goes so far crazy on the Fourth Amendment and the First Amendment. I can't imagine it pulled up anywhere. And I haven't seen it pulled up anywhere.
And that provider in that case wouldn't be a target for being interfered or obstruction to that warrant.
The government, I mean, the way that warrants work is their directions to law enforcement, not to anybody else.
How does all of this intersect with the code of ethics that healthcare providers have taken that include informed consent?
And that is beyond the scope of my knowledge, and I would actually recommend, because now that I've realized where this problem is coming from, and that it involves the question of healthcare providers and, you know, to some degree or another, maybe the distinction between consent to a medical procedure and consent to a search. I think maybe this should require bringing in some healthcare providers to talk about that, because that's something I've heard only sort of thirdhand through talking to our DUI on-call attorney. I don't really want to comment on the medical ethics of it. That's certainly.
I mean, we have laws on the books that that
my
demand informed consent and ethical codes that you could lose your license for. So I think there is an important intersection here. And I have significant concern if we're starting to talk about criminalizing someone for upholding their code of ethics. So
Any further questions? Thank you.
Thank you.
We're gonna hear from Lynch Council for a moment, and then we'll
So I just, for the record, Ben Bobrovsky from the Office of Legislative Counsel. I just want to reorient the committee to the language of the bill and sort of how it progressed in the House. So in the House, there was a lot of testimony that kind of was the genesis for this language, which was what happens when someone refuses to submit to a warrant that's validly issued by a police officer, right? And what was testified to is it really ties the hands of law enforcement, because if they don't submit to this blood draw that is pursuant to a warrant, their options are limited. And so typically what would happen, as testified to, is that the person refusing to submit to that warrant-based blood draw would be charged with either obstruction of justice, hindering arrest, And these are felonies, which really escalate outside of the world of DUI penalties, which are for the most part misdemeanors with rehabilitative aspects. So this language was proposed to keep any failure to comply or submit to that warrant within the DUI sanctions rehabilitation world, right? Which is why a refusal to collect the evidentiary blood sample that's based on a warrant could now be considered a criminal refusal. And so the reason why this was done is that so it didn't unduly escalate the penalties associated with trying to obtain evidence. So so I think what's happening here is we're conflating a consent analysis with a search warrant analysis. Consent, Fourth Amendment, you can't be compelled to consent. It's sort of this constitutional conditions doctrine, where if you are essentially coerced into consent, no bueno, that's what we're talking about sort of on the consent side. But then there's a warrant compliance, which, as Attorney Paul said, really places obligations on the law enforcement officer. You have to search someone based on the four corners of the document, limited to what's listed, that's searchable, time, place, manner, a bunch of things. We're talking about a warrant to draw someone's blood. This doesn't necessarily reach or affect a medical practitioner who still may refuse based off of their own medical ethics, license requirements. What this is doing is really looking at what choices does law enforcement face in a situation where they have a warrant to draw blood and the person does not let them comply or submit to that warrant. They can still refuse to consent, but that consent is like an exception to a warrant requirement. So if you consent, it obviates the need for a warrant. But once you have that warrant, it doesn't matter. And so because a warrant provides the legal authority to the officer to get the evidence they need, regardless of the consent of the victim or the subject of that, of the search. So there's two separate issues here. And what this was identified as in the House was really limiting it to the interactions between the officer and the subject. And when that officer has a warrant, what happens if someone doesn't submit to the warrant requirements? It still may lead to the same issue with the medical practitioner, where you have the warrant, you might, and when the person's incapacitated or they refuse to give consent, they still may not draw the blood of that person based off of their own medical assessment and needs and all that. This, in my view, does not get to that issue. This is purely about the subject of the warrant and if they fail to comply.
So if I'm understanding correctly, would it make more sense than to clarify the language to make it more specific for physically resisting when there's a warrant issued and they're trying to draw blood, and making that a criminal refusal rather than a felony?
I mean, and that's a policy decision based off of the whims of the committee. I mean, you could absolutely do it if the term refuses or shall not refuse to submit. If that word refuse is sort of the crux of the concern, that can be changed. But again, these additions to the bill are all contingent on the warrant first. It's not about a warrantless search. It's not about search incident to arrest. It's not about any exigency, because those are exceptions to the warrant requirement.
So if a warrant, so I'm seeing it now when a warrant for that person's blood is issued. So it wouldn't then affect, if there's no warrant and somebody says, yeah, I don't want to participate in this, they wouldn't be charged with criminal refusal.
Correct.
Okay.
And that goes to your question about implied consent. And as Attorney Paul said, in Birchfield, they said, nope, the implied consent does not reach a warrantless blood draw because it's too intrusive and you can get too much information. The implied consent carries over to the breath test, but you need a warrant to obtain a blood draw.
Yeah, it's helpful. So matters.
What if you just sit there and don't say a word? Is that resisting the warrant, but you're not saying anything?
Well, again, you know, it's a little complicated when it comes to resisting a warrant,
Yeah.
right? Because the warrant, you don't technically need, it's an obligation on the law enforcement officer, and you don't technically need the consent of the subject at that point. Now, if they're just sitting there, I mean, I think that's a fact-based inquiry that based off of what really happens would inform if there's a basis for a criminal charge or not on a different, from a different angle. But you know, I think that that wouldn't necessarily, yeah, I think it's fact dependent is the short answer to the question.
It's helpful. Okay. Actually, any other questions for Ledge Council? Okay, thank you.
Thank you. My name is Dennis Freedmans. Attorney's Sheriff's Department. I'm what is referred to as a advocate resource prosecutor. I'll try to be as brief as possible. The very first thing I wanted to address with regard to the healthcare providers, this bill does not propose funding healthcare providers whatsoever. The bill proposes creating a crime where a person has been subject to a warrant that an officer has been granted by the judge, a crime of DUI as opposed to a crime of impeding, or a crime of obstruction of justice. Impeding is a 3-year felony, obstruction of justice a 5-year felony. If you're convicted of either one of those, you don't face any of the DUI sanctions of license, loss of license, SR22 insurance, or any of the rehabilitative options through the Department of Corrections that one may take advantage of if they're convicted of the DUI. And so we felt that it was more fair to take a look at this small group of individuals. Because we are talking not about all DUIs. Most people actually do, once the warrant is granted, concede and then allow the, in most cases, a nurse to do the draw. Our read of Birchfield is clearly different than Attorney Paul's read of Birchfield. In that, one of the things that Attorney Paul glossed over was the warrant exception, right? And that is that Birchfield says that breath tests are per se reasonable when an officer has probable cause to believe a person has committed a DUI. And so under those circumstances, a person must comply under the implied consent or face a refusal charge and possible conviction. Under those circumstances, refusal has been determined by both Birchfield, our own state courts, and many courts nationwide. Refusal could be expressed through words, actions, or inaction. Now, what I find interesting is that essentially what the Defender General is proposing is that you have to actually have a physical confrontation between law enforcement and an individual in order for the crime to be constitutional, but an actual manifestation of one's intent not to isn't sufficient. Many states, as Attorney Paul alluded to, the way that they resolve this problem is by simply strapping the person to a chair and drawing their blood. Law enforcement officer has been told by a judge to go ahead and draw that blood without any limitations, generally speaking. We find that to be a barbaric practice, and we don't think that's where our state wants to go. Our state has long recognized that a person can actually be charged for DUI refusal by stating, "I do not consent." Birchfield does nothing to change that so long as a warrant has been issued. What Birchfield says is that blood draws are per se unreasonable without a warrant.
Once you obtain a warrant, that renders the police subsequent request for blood as reasonable under the Fourth Amendment. That's our perspective. I know the Defender General has a different perspective, and we're not here to debate that. And we don't believe this is the proper forum for that debate. The proper forum would be the Supreme Court, because Birchfield doesn't rate what happens when a warrant has actually been granted and there's a crime for a person not complying with an officer's request subject to that warrant. Does that make sense? Now, there's already a law, as Marshall also testified. Back when Birchfield occurred back in 2016, we vetted all of our DUI statutes to determine whether or not our statutes complied with Birchfield. One of those statutes was 1202 D6 under Title 23. In that statute, if a law enforcement officer has essentially what they call reasonable grounds, which our Supreme Court has said is the same thing as probable cause. If a law enforcement officer has probable cause to believe that a person has any amount of blood or alcohol in their system, and another person has suffered a serious bodily injury or death as a result of the crash, then the law enforcement officer can request blood, as long as the other exceptions that Attorney Paul referenced are present.
They can request the warrant for blood.
They can request a person to give blood, and then if the person refuses, they can then obtain a warrant, and the person can be charged with refusal. It's in our statutes, right there in Title 23. You look at 1202 D6. And so we already have this, it's already been vetted. All we're doing is now applying it to a different circumstance where somebody has been accused of committing DUI, which is probable cause they actually are impaired while driving, as opposed to any amount of drugs or alcohol in their system. It's a higher standard. Okay. And so a judge reviews it, finds probable cause that a crime has been committed, that then issues a warrant. The officer has the warrant. The officer then requests a sample of their blood. That warrant, we believe under Birchfield, renders it as reasonable. That request as reasonable. It was unreasonable without a warrant, reasonable with a warrant. That's what Birchfield says. And as I said, I think this makes sense because the law, we believe, would not conclude that a physical confrontation has to occur before this crime. If a person actually does express their intent not to comply, why do we want to put police officers and suspects in a position where there's going to be a further physical contact between the two? In other words, if the person has to physically recoil, that presumes that someone's going to be trying to hold them down. And we don't believe that's what the law requires. And that's not what we should require.
So hold on a second. So now I might be a little confused. So are you suggesting then that if somebody is saying, I don't consent, then they should be charged with criminal refusal?
If a warrant has been granted.
If a warrant is granted, okay. But
they have been charged with criminal refusal if it's a practice already.
Right. So if they say, I don't consent, and then the officer gets a warrant, and then they get the blood, there's no physical resistance or anything, then they wouldn't be charged with criminal refusal, is what you're saying?
Correct, because then they've already succumbed to that second request for law.
Thank you.
So just so I know, right, you can be on the side of the road, refuse a breath test, that would result in a violation, correct?
No. So on the side of the road, it's a preliminary breath test device. That's not an evidentiary device. An evidentiary test has to occur, and those occur back at the police
Okay,
station.
so now you're back at the police station.
Right.
You refuse that breath test,
After consultation with them, if you so choose.
then you can have that violation of refusal, right?
Correct.
And then it moves ahead because you refuse that. they then ask you for a blood test, you can refuse that.
It's not, no. So if a DMT is actually available,
Yep.
and we believe the person is committing the crime of DUI alcohol, then you can't apply for a bond.
Unless it was bodily injury or.
Unless there's bodily injury or death resulting, if you can't get to the DMT.
Yeah.
You still have that predicate of the DMT is the instrument that tests VAC through your breath. Okay, we're really talking about largely DUI drug cases here, where, we don't have a testing device that has a per se limit associated with that. And there are all kinds of ethical reasons why that's the case. For example, we're not going to validate tests where we have to, dose subjects with fentanyl or something like that to see whether or not the individuals, whether or not the tests can be validated in a lab, for example. Does that make sense? It's the difference between valid tests versus validated tests. Validated tests is where you dose somebody with a known amount of a substance and then test the theory to see if it holds true. That would be unethical. Terribly unethical. But we also think it would be unethical to hold people down. We don't want to be in that position. And that's how a lot of other states have addressed this issue. I do agree with Attorney Paul that one solution would be to have it be lawful for law enforcement to be able to do blood draws. They have a number of states that do that, and they've been very successful. It also majorly cuts down on detention times, which is something that I'm very concerned about, both with individual liberty, but also with taking law enforcement officers in very small departments off the road. Want to talk about masking really quickly? I know you guys had some masking questions.
Yeah.
Okay, so commercial driver's licenses, I'm sure Attorney Paul will learn, and later, a juvenile under the age of 18 cannot receive a commercial driver's license, but a juvenile who is 18 can. And so that's why juveniles are pulled into the statute. As he mentioned, commercial driver's licenses are actually federal licenses. They're not state licenses. When you get a commercial license, you give up your state license. You can't have both at the same time. Okay. Last year, the bill passed a new law to conform with the federal statute that relates to masking, and that is that if there is evidence of DUI, we can, as state's attorneys, we lack the discretion, judges lack the discretion to amend that charge if the evidence points towards the DUI. They have to try the case essentially as a DUI. There's no discretion whatsoever because we aren't a part of the federal arm. We've been deputized, so to speak, in exchange for receiving federal funds for that purpose. That makes sense. So 4112 essentially conforms to the federal statute that says that if you have a commercial driver's license, state's attorneys, judges lack the authority to amend the charge outside of an evidentiary problem. If there's an evidentiary problem, then you have the authority to exercise your discretion. As far as losing your licenses under the FMCSA, which is the Federal Motor Carrier Safety Administration, the regulations are 1 DUI and you receive a 1-year suspension on your CDL, 2, and you receive a life suspension. So I think that answers Senator Hoskins' question.
I think, Blackton, did you have any further testimony?
Just insofar as the other amendments weren't addressed, I don't know if you all want us to walk through them at all. I don't know if you're going to cover that during the walkthrough.
Well, I already walked through the bill.
Oh, you did? Okay, excellent. All right.
I suspect we're gonna have more questions in the near future, but I also want to give Judge Zone some time to testify. So I believe he's in the, is he in the Zoom?
Yeah.
Yeah.
Oh,
I think, yeah, we might have you back or we might send you some emails,
Sure.
but
I mean, I think, although Attorney Paul didn't testify to it, we all have broad agreement on the other amendments. They help to clarify areas that have been gray areas in the law, frankly, and will allow public defenders to more adequately, counsel clients, but also will provide the courts with greater clarity
Thank you, appreciate it. Next up, we have Judge Zone joining us. So,
Morning,
right.
Tom Zone, Chief Superior Judge. So this may be quick. I think when you have the state's attorneys starting out saying our read is different of Birchfield and then saying the proper forum is the court, that they have indicated that I can't give a lot of comments about which way to go on this as you look at it, because the court will have to decide it. There's a number of questions that the court will have to decide. And if you enact a statute like this, and that is, what if the defendant says nothing? You've talked quite a bit about, well, if they don't consent to the blood draw, what if they just sit there in the hospital and don't say anything? Is that a violation of the statute? That will be for the courts to determine. The court will have to determine whether it's different than a situation where police show up at somebody's door and knock with a warrant, and the person just sits in the living room and doesn't get up and open the door and let them in. These are the types of questions that we'll have to address.
Thanks for being here, Judge Zone. I am wondering if sort of under the law, the courts view a building differently than a person's body, because I view not saying, no, you can't come in versus no, you can't violate my body.
That is why I use that. Exactly. That's why I use that analogy, because the court will have to decide whether there are Fourth Amendment differences, whether Birchfield and other Fourth Amendment jurisprudence and our protections in Vermont under our Constitution, whether they're treated the same, whether they're treated differently. And so I can't opine on that today, because these are precisely the types of issues that the court will be called upon to decide. I would note that I saw that Mr. Paul put up some suggested language, and he did use the word inhibit. I would only note that if you were going to go in that direction as a policy decision, you may possibly want to consider the word hinder as opposed to inhibit. Hinder is a word that is also, as you know, is in the statutes for hindering officers. I don't know of statutes, maybe Mr. Paul or Mr. Rigmans are aware of ones that use the word inhibit, but I think hinder is more of a word that we would recognize. But again, that's a policy decision if you go in that direction.
Thank you. Committee, any questions?
Not that the judge can answer.
And I would note that some of the other changes are clarifications. And so we certainly have no issue with the other provisions where it makes it very clear that the intent is to make certain reports to the Department of Motor Vehicles. It also makes it clear that on the civil, it's at or above. So certainly those are policy decisions. We take no issue with those.
Thank you. So I know we have you on for H98 at 10:45. We can go in for a bit. So I want to give the committee a 7-minute break, and we'll come back at 10:40 and